Mr. Peñalver to lead our opening prayer.
Presence in the name of the Father, the Son, the Holy Spirit. Amen. When we live in unity, how good and how pleasant it is. Pray for us, Holy Father Saint Augustine, that we may dwell together in peace. God, our loving Father, Jesus, your Son, our brother, perhaps to be present in the midst of all who comes to be present in the midst of all.
Who come together in your name.
Wait, for a while, sir.
Amen.
Sorry, sir. Thank you, sir. Sorry, sorry, sir. Thank you, sir.
Alright.
Amen.
Thank you, Mr. Peñalver, for that very meaningful prayer. Anyway, sige. So let's start our lecture now for this afternoon. By the way, I already made my. I already informed the Beatles about the plan. I've not yet received the response. So let's just wait for that. All right. Anyway, this afternoon or this evening, I'll be discussing articles of incorporation and bylaws. Okay. Okay. So let's start. Now, when we speak about a corporation being organized, the first thing that we have to consider is, well, of course, who are the movers of this corporation? Then, what would have to be their purpose for organizing a corporation? What would be the type of corporation that they're going to form? Would it be something which would be used for business, or a corporation that is going to be used for eleemosynary or social civic or other purposes? Then the choice would have to be coming from the incorporators themselves or the movers of the corporation. Then that's the thing that we need to consider, because in forming a corporation, we as lawyers, we should know what direction the corporation will go, because we need this type of information in order for us to assist our client in the preparation of this particular document. It's very important that this to be submitted the Securities and Exchange Commission for it to consider whether a corporation should be allowed or given the privilege to exist as such. Now, this particular document that I'm referring to is the Articles of Incorporation of a corporation. And of course, we already include therein the bylaws of the corporation. Now, the preparation of the Articles of Incorporation should be in accordance with what the law requires. The same is true with the bylaws of the corporation. But what is the nature of the Articles of Incorporation? Some say that it is both a document, a piece of document, and at the same time, it is a contract between the corporation and those stakeholders that it relates to once it is granted by the law the privilege to exist via the issuance of a certificate of a corporation. So commentators would consider that the Articles of Incorporation is both a document and a contract. Now, in a case that was cited by Dean Villanueva in his book, case of government of the Philippine Islands versus Manila Road Company, this is a very old case. The Supreme Court had the occasion to characterize the Articles of Incorporation. In that particular case, the court said the Articles of Incorporation, or which is also referred to as the corporate charter, is characterized as a contract between, number one, the state and the corporation, as the state and the grantee of the said charter are equally bound by its provisions. Now remember, when the incorporators of a particular corporation submits to the Securities and Exchange Commission the articles of incorporation, it already states therein the very purpose for which the corporation was formed by the incorporators. And of course, the entries in that particular articles of incorporation bounds both the corporation and the state. And so far as number one, the purpose or purposes for which the corporation was organized, and of course, the term of existence of the corporation. So those are some of those items that are significant when we say the entries in the articles of incorporation binds both the state and the corporation. It's also characterized as a contract between the shareholders and the state. Right? And lastly, it is is characterized as a contract between the corporation and its shareholders. Of course, we will later on also learn that when we form a corporation, we also recognize the relationship between a corporation and the third persons that it deals with. So third parties or third persons with which the corporation is dealing is brought about by reason of the objective for which it was organized. So let's say if we're talking about a stock corporation, then it is geared towards engaging in business. So if the corporation engages in business, logically it would be dealing with third parties. For example, suppliers, creditors, also its customers or its clientele. It would also even include its own employees. From the point of view of a relationship between the corporation and its employees, it could be properly characterized as the relationship between a corporation and third persons, because employees are properly considered as outside of the intra-corporate relationship between the corporation and its shareholders and its directors and officers, as we will later on, of course, learn. Now, so that's how the state or the court characterizes the corporation's articles of incorporation. It is a contract which binds corporation to those with which it has relations with. Now, of course, when we consider what are supposed to be included in the articles of incorporation, we will then learn that these are the basics that we need to comply with. Now, according to Dean Villanueva again, a corporation's articles of incorporation, once it's submitted and approved by the Securities, submitted to and approved by the Securities and Exchange Commission, and of course, it results to the issuance of a certificate of incorporation, it constitutes every duly registered corporation's charter and the basis by which to adjudge whether it exists for legal purposes as well as the extent of its powers and capacities. Now, yesterday, when we had our discussion on corporate powers, we emphasized on the importance of a corporation's primary purpose as one of the sources of a corporation's corporate power. Right? So this primary purpose is properly lodged and stated in a corporation's articles of incorporation. Right? Now, when we prepare the articles of incorporation, the provisions of law that is applicable would have to be Section 13 of our revised corporation code, as well as Section 14. Section 13 gives us an idea of what are supposed to be stated in the articles of incorporation, how it's going to be submitted, and of course, our Section 14 gives us the basic form of the articles of incorporation. Of course, the succeeding provisions, Section 16, Section 17, and Section 18 are also relevant when it comes to the submission of the Articles of Incorporation, as well as the approval thereof by the state through the Securities and Exchange Commission. Now, how do we then start the ball rolling when it comes to the incorporation process? Of course, we might want to look into the provision as provided of the RCC as stated under Section 18 of the Code. Right? The first sentence of Section 18 does that a person or group of persons desiring to incorporate shall submit the intended corporate name to the Commission for verification. So that's the first step that you have to do. Of course, the preliminaries should already be considered, just like meeting or having a conference with your client, discussing with them all of the steps that are to be taken. But when it comes to the procedure, Section 18 would guide us that the persons who wish to incorporate shall first have its corporate name submitted for verification. Now, after all of these things have been encoded in our SECS part, then the Articles of Incorporation should be submitted to the SEC. Now, Section 13 of our RCC states, all corporations shall file with the Commission Articles of Incorporation in any official language, duly signed and acknowledged or authenticated in such form and manner as may be allowed by the Commission. So I would like to emphasize on what is provided in the first paragraph of Section 13 insofar as the submission of the Articles of Incorporation. Number one, the Articles of Incorporation should be filed with the Securities and Exchange Commission in order for the SEC to go over and review the contents of the AOI submitted. Second, it may be in any of the official languages, but of course, under the SPART, the Articles of Incorporation that is provided by the SEC is in the English language. Third, it must be duly signed and acknowledged or authenticated. So there must be a process of authentication. Right? Now, the Securities and Exchange Commission provides for the procedure for the authentication of the Articles of Incorporation as required under Section 13. So this is provided in SEC Memorandum Circular number 16-2020, where the SEC stated and provided that when the authentication of the Articles of Incorporation is done in the Philippines, then these are the modes of how the AOI should be authenticated. Is authentication, again, necessary? Yes, because it is required under Section 13 of the RCC. So how is authentication being done? Number one, it's through a certificate of authentication designed by all of the incorporators in the form prescribed by the SEC, or it could be merely just acknowledged before a notary public. So the one that we usually do is to have the Articles of Incorporation as provided by the SPART printed out in a hard copy, have it notarized by a notary public, and then upload it again to the system. So that's how it's being done. Now, what about if the Articles of Incorporation, is there a possibility or is there an instance where the Articles of Incorporation of a corporation is signed and authenticated outside of the country? Well, the answer to that is yes. Now, next question is, would it result to the corporation being considered as a foreign corporation? The answer to that is no. Why? Because when we look at the place of incorporation test, we're not referring to the place where the Articles of Incorporation was signed or authenticated, but we're looking at the law under which the corporation was incorporated. That's the place of incorporation. That it's the law. So if the law that was used is Philippine law, then that is considered as a domestic corporation. If the law under which the corporation was incorporated was under laws of countries other than the Philippines, then it's considered as a foreign corporation. But there is a possibility, like for example, since we're now doing it online, the corporation, all of the incorporators, let's say, who are Filipino citizens, are, let's say, currently in a country outside of the Philippines, let's say, in the United States. So pwede ba silang could they establish or organize corporation that is domestic? The answer is yes. All that they have to do is enroll in the SPARC, fill all of the information therein, have the articles of incorporation printed, and then have it authenticated outside of the Philippines. Now, how is it done? Under the SEC memorandum circular that I have mentioned, it could be subjected to an apostille, or apostille in accordance with the 1961 Hague Convention on the abolishment of requirement of legalization for foreign public documents. So this is what we call as the apostille convention. So, syempre, there are only several countries in which apostille is or signatories to the said convention. The United States is one of them. I think Canada is not. So, yun. So, let us say if it's a country like Canada, which is not a signatory to the convention, then how could it be authenticated? It could be done by way of notarization or authentication by any Philippine diplomatic or consular officer. So, yun. So, what happens now? So, the Articles of Incorporation of a corporation formed under Philippine laws is basically we're organizing a domestic corporation. However, the AOI was just authenticated outside of the country. Right? So remember that. Okay? And now, so Section 13 tells that all corporations shall file with the Commission articles of incorporation is duly signed and acknowledged or authenticated in such form, okay, and manner as may be allowed by the Commission. What does it tell us? Right? What does it tell us? It tells us that the Articles of Incorporation is a solemn contract. It's a solemn contract. Why? Because if you look at the provisions of Section 13, it clearly tells us that it should be in a form that is prescribed by the Securities and Exchange Commission. Right? In such form and manner as may be allowed by the Commission. Right? So why is it a solemn contract? Because in order for the SEC to grant or to approve the Articles of Incorporation, which would now lead to the issuance of a certificate of incorporation, it is imperative that the AOI should be in the form that is prescribed by the Articles of Incorporation. And since we already established that the Articles of Incorporation is the contract that binds the corporation to all of these persons or entities that it relates to, then it is required to be in that particular form. Now, we also find justification for classifying the Articles of Incorporation as a solemn contract under the provision of Article 1356 of our new Civil Code. Ano yun? What is stated under Article 1356, if you remember? Contracts shall be obligatory in whatever form they may have been entered into, provided all essential requisites for their validity are present. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that the contract be proved in a certain way, that requirement is absolute and indispensable. Right? So therefore, when the SEC prescribe a specific form, no, of the Articles of Incorporation, that should be followed. Now, is there now an opportunity for us to miss a particular item to be included in the Articles of Incorporation, which would lead to the disapproval thereof? Well, the chances now are getting slim. No? Why? Because we are doing the incorporation process through the SPARC. Okay? So pag SPARC siya, the chances of leaving out something becomes more slim, no? Because before you could proceed to another field that you would be you know, making an entry, the system would return you back. No? May nakabutang asterisk, you have to fill this field up. So, the chances of missing something is getting really slim because of how it's now being done by the SEC. All right. Now, what then are the grounds, no, for the SEC to disapprove the Articles of Incorporation? Ano bang pwedeng magamit ng SEC na reason for disapproving the approval of the Articles of Incorporation? Now, the controlling or the applicable provision would have to be Section 16 of the Code. Okay? The Commission may disapprove the Articles of Incorporation or any amendment thereto if the same is not compliant with the requirements of the Code. Okay, so number one would have to be form. Pag hindi siya compliant with the form, since we are established that it's a contract and it's a solemn contract, then that would have to be a reason or a ground for the SEC to disapprove your Articles of Incorporation. When will this become relevant? Our knowledge of when the Articles of Incorporation will be disapproved. When we want to apply what we have learned in the two cases that I think we have taken up in the previous meetings that we have, referring to the case of Seventh-day Adventist and the case of the case of Seventh-day Adventist and the case of Missionary of Sisters of Our Lady of Fatima versus Alzona. No? When we are considering whether a corporation is a de facto corporation or would the doctrine of corporation based token would be applicable. So yun. Alright? So that's something that we need to remember. Okay. Now, so under Section 16 of the RCC, some of the grounds for the SEC to disapprove the Articles of Incorporation are the following. Number one, when the Articles of Incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. So, anong form? So, as I've said, Section 14 of the Code gives us what are supposed the form of the Articles of Incorporation. However, since we're now using the SPARC, okay, then the chances of not being able to fully comply with the form is now, it's improbable to happen, but who knows? So kung hindi in accordance with form, then this could be used by the SEC as a ground. Second, the purpose or purposes of the corporations are patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. So the purpose clause for which the corporation is organized or established is illegal. So yun. Of course, the SEC would have the reason to disapprove the AOI. Third, when the certification concerning the amount of capital stock subscribed and or paid is false. Now, this refers to what? A stock corporation, because it's only a stock corporation which has an entry pertaining to capital stock subscribed or paid up. Why is this important? Because the SEC recognizes the right of creditors. No? over of their claims against the corporation by reason of the limited liability feature in a corporate setting. Kumbaga, creditors of the corporation look into the authorized capital stock or the capital stock subscribed as a source for them to claim, no, or to lay claim for their for the money or credit that they have given to the corporation. So claims nila could be satisfied from the capital stock. So if this is false, then it would prejudice corporate creditors. That's the reason why if the SEC finds out or discovers that the certification relating to capital stock subscription is false, then it is a ground for the disapproval of the AOI. And lastly, the required percentage of Filipino ownership of the capital under existing laws on or the Constitution has not been complied with. Well, we're also familiar with this because of our extensive discussion on nationality of corporations. Right? For corporations engage in areas of activity where the Constitution or some law require a certain percentage of Filipino ownership, then we must be able to satisfy that even in our articles of incorporation. Pag there is a problem therein, then, okay, it could result to a corporation being issued a certificate of incorporation, but there would have to be a defect because of this particular reason. Hindi siya compliant with the requirement of the Constitution insofar as the minimum required Filipino capitalization. So yun. So pwede yun. No? So how would the SEC flag this? By just comparing and looking into the primary purpose of the corporation and the capital structure at the time of corporation. So example is if it in the primary purpose of the corporation stated there that it is organized to engage in the business of mining or exploitation and development and utilization of natural resources. So what does it tell us? It's a corporation that is geared towards operating or engaging in an area of activity where the Constitution requires what? At least a 60% Filipino capital. Because that's the requirement of the Constitution. So in the articles of corporation, the SEC would now look into, but this is the primary purpose, that it would have to correlate it with its capital subscription. Ang tawag nila, how many shares or how much of the capital is at least 60% Filipino owned. So it would be checked by the SEC. Now, it would also be presented as part of some drop-down choices that would have to be also entered by the, I think, lawyer or even the accountant that is assisting the incorporation process, in the incorporation process. Yun. So those are the grounds for the SEC to disapprove the articles of incorporation submitted to it for consideration. Now, we now go to the AOI proper. Okay. So what are the contents of our articles of incorporation? Now, it's important for you to be able to be familiar, what are the contents of the AOI, so that later on when you're going to be requested to assist with the preparation and the processing of the AOI, then you would have a fairly good idea of what is to be stated in the articles of incorporation. What is the governing provision of the RCC pertaining to the contents of the AOI? Again, that would have to be Section 13 of our RCC, which states, all corporations shall file with the Commission the articles of incorporation containing substantially the following matters, except as otherwise prescribed by this code or by special law. So, why am I referring to this? Because there are certain special laws which adds to the basic requirements stated under Section 13. Okay. An example of which is if the corporation will be engaged in an area of activity where it needs to sell securities. Kumbaga, if it's going to sell certain securities which are covered by the Securities Regulation Code, then there would be an additional entry in the said Articles of Incorporation stating that they're undertaking to abide by the provisions of the Securities Regulation Code, which is something that is not provided under Section 13 because it's required by a special law. The same is true when you are going to incorporate a financing corporation or a lending corporation. So the law itself requires for the inclusion of certain provisions. Another one would have to be if the corporation is going to engage in a business which is considered by law as one which is vested with public interest, then there must be the provision for independent directors. So it may not be required in ordinary corporations, but because of certain provisions in special law, it is required in specific corporations. So Section 13 would be your guide. What would have to be stated in or provided in the Articles of Corporation. So the first one in the list is the name of the corporation. Okay? The name of the corporation is governed by Section 17 of our Revised Corporation Code as well as by SEC Memorandum Circular Number 13, Series of 2019, which is the amended guidelines and procedures on the use of corporate and partnership names. Now, when should we submit the corporate name for approval? As I've already mentioned earlier, Section 18 of the Revised Corporation Code provides that a person or group of persons desiring to incorporate shall submit the intended corporate name to the Commission for verification. If the Commission finds that the same is distinguishable from a name already reserved or registered for the use of another corporation, not protected by law, and is not contrary to law, rules, and regulation, the name shall be reserved in favor of the incorporators. Remember, and please take notice, the word that is used by the code or by the RCC is just the name shall be reserved. Right? Why? Because we're still in the incorporation process. Kumbaga, for the purpose of being given a corporate name, this particular name that you chose, all right, would be reserved until such time that the incorporation process is finished. Okay. But of course, there's still that window where the SEC would require the corporation to use a name other than which was reserved. Now, what is the significance of a corporation's name? So, just like a natural person, your name is very significant to you because that's the name by which you will be known by your peers, family, by all those who would be dealing with you. So that's also the same or similar to a corporation because it's a juridical person. For me, the name of a corporation is significant because it's by that name that the corporation would be identified and would be known. That's the reason why. There are corporations who take good care of its corporate name. And when there are instances when its corporate name is besmirched, then they are adamant in filing cases seeking damages for ruining that good name. So, that's very important for a corporation. Now, the name of the corporation is essential to its existence as a juridical person enjoying a separate and distinct legal personality. So, kumbaga, that is the name with which it should be known. Now, under Section 18 again of our code, once a corporation begins its corporate existence, it shall constitute a body corporate under the name stated in the Articles of Incorporation for the period of time mentioned there. So during the lifetime of the corporation, it should be known by the name that is registered in its Articles of Incorporation. By the way, Mr. Biddle, so far is my signal okay?
Yes, sir.
All right, thank you. Kagina, I noticed that there's some lag. Anyway, sige, continuing. So Section 18 tells us that once the corporation begins its corporate existence, then it should be known as a body corporate under the name that is stated in its articles of incorporation. Right. Now, it is also by its corporate name that the corporation may sue and be sued and perform and exercise its corporate powers, such as to enter into contracts, for example, the purchase of properties. Since as a person and as we have learned under the provisions of the Civil Code, and in particular when we are looking at persons, sino bang mga persons that we are considering under the Civil Code. So under Article again 44, paragraph 3, of course, corporations, partnerships are granted this separate and distinct legal personality, and under Article 46 of our Civil Code, juridical persons may acquire and possess property of all kinds. Diba? So, and of course, as we have learned yesterday in our discussion, one of the specific or express powers of the corporation is to be able to purchase or acquire properties, real and personal. So if we're going to look into the registration of these properties with the proper government agency in charge with custody and registration, then that property should properly be registered under the name of the corporation. So that's the reason why it's very important for us to be able to establish the name of the corporation. Also, it is by that name that the corporation could exercise its power to sue and be sued. And that's expressly also provided under paragraph A of section 35 of our code. Okay. Now, of course, I have assigned for your reading some cases relating to the use of corporate names. We'll go to that later on. Now, in the case of De La Salle Montessori International of Malolos versus De La Salle Brothers Incorporated, the Supreme Court held that the corporate name is a property right, a right which is in rem, which it may assert and protect against the world in the same manner as it may protect its tangible property, real or personal, against trespass or conversion. So that's that's the pronouncement of the Supreme Court in that particular case. Corporate name is a property right. Now, also, of course, in the cases that I have assigned for your reading, okay, we learn that in the case of rural transit, alright, I'm looking at the okay. Right. The case of Red Line Transit versus Rural Transit, the Supreme Court held that the name of a corporation is essential not only for its existence as a juridical person, but also in the manner of dealing with it and in the exercise of its juridical capacities. It cannot be changed except in the manner provided for. In the case of Laureano Investment and Development Corporation versus Court of Appeals, the Supreme Court held that a corporation has no right to intervene in a suit using a name, not even its acronym, other than its registered name, as the law requires, and not another name which it had not registered. Well, remember in the case of Laureano Investment and Development Corporation, what they used as a name was Lideco. It's a shortcut or an acronym of the corporate name. So the Supreme Court held that you cannot use that one because it's just like a nickname, okay, of a corporation. Let's say if you're going to shortcut a particular name, well, it's not the one that is stated in its articles of incorporation, and it should not be referred to it in a suit. using a name other than what is stated in its articles of incorporation. That's the pronouncement of the Supreme Court in the case of Laureano Investment and Development Corporation. So let us say, for example, if the name of the corporation as registered is Jollibee Foods Corporation or JFC, you cannot use Jollibee lang or JFC lang. Alright? It should be the name of the corporation as stated in its articles of incorporation. However, there is one case. I think you also read this one. The case of Pison Narceo Agricultural Development Corporation versus NLRC. And in that case, the Supreme Court held that there is no denial of due process when a corporation is sued and judgment is rendered against it under an unregistered name. Right? A corporation, according to the Supreme Court, okay, may be sued under the name by which it makes itself known to its workers. All right. Now, in this particular case, the farm workers sued, okay, their employer using not the corporate name as stated in the AOI, but the name by which the hacienda was known. Was sued under the name Hacienda Lanutan. Of course, included therein was the officer of the corporation. So the Supreme Court saying that, well, they were not deprived of due process when they were sued in this particular name. Well, it's understandable because this is a labor dispute, and of course, based on what we have learned, labor law and constitutional law, we should not decide labor cases based merely upon technicalities. So yun. So you remember this one. The case of Laureano Investment and Development Corporation and the case of Pison Narceo Agricultural Development Corporation. Alright. Now, so what names could a corporation use as its corporate name? Well, of course, no. Pag natural person, well, it's up to your parents to come up with names that would suit their fancy, or maybe that would be dependent. The damo basis, there are those who are partial to their ascendants, parents than parents. There are those who are influenced by their idols, the artista or basketball player, whatever. So there's no hard and fast rule when it comes to natural person and the use of first name. First name. You could even copy the first name of your idol. Let's say your idol is Cheese Escudero. So Francis Cheese. Pwede mong gamitin. Francis Cheese. O gusto mo si Curly Curly the Cesera, yun, idol mo. So, or Bryce Henry, na bilyonaryo. So, there's no hard and fast rule when it comes to individual persons, right? Pwede mo bang pangalanan yung anak mo na Satanas? Si Satanas? Well, but it's only a name that is common here in the Philippines. But what if sa mga sa mga African countries, they don't know what the meaning of Satanas is. So yes, pwede. But what about corporations? What names could a corporation use? Now, we should be guided by the provision of Section 17 of the Code. Section 17 states that no corporate name shall be allowed by the Commission if it is not distinguishable from that already reserved or registered for the use of another corporation, or if such name is already protected by law, rules, and regulations. Right? So, when we look at the provision of Section 17, it tells us that a corporate name shall not be allowed by the SEC if, number one, it is not distinguishable from that already reserved or registered for the use of another corporation. So you have to distinguish one corporation's name with that of one which is already being used. So, well, uh, it's kind of um, uh, now easy for the SEC to rule whether or not a name could be distinguished from the other. So, kumbaga, you just use the ordinary meaning of distinguish, and then that's it. So usually, what incorporators do, they add to, let's say they have the main name. They just add there to some other words to distinguish it from another, or to you know differentiate it from the other. So, for example, if you're fond of the word okay, diba? So okay is considered as now as a generic word, but before it was just considered as a coined word. That means you're all right or whatever. So let's say there are so many people who wants to use the word okay for its corporate names. Right? Let's say okay trading, okay marketing. Let's say it could be descriptive of your services. Okay Laundry Services Incorporated, OK Messengeral Services Incorporated, yun, OK Construction. So it's kind of describing the particular business, but it's kind of generic. So in order for you to distinguish it from other names, then you could add other words. Okay, so when the revised corporation code was passed, no? So it made it much more easy for corporations to distinguish its corporate name from others by just using or adding thereto some kind of name. So I remember one of our clients used just added the word PHL, no? To the original corporate name, and then the SEC already approved it because it distinguished it from the old corporate name. So, ibutan nyo lang, open parenthesis PHL, close parenthesis incorporated. So, pwede na because it already distinguished it from another name. But of course, as I mentioned earlier, the SEC came up with its revised guidelines in the use of a corporate partnership name. All right, so I leave it up to you to read that particular memorandum circular so that you'll be familiar with what names are allowed or not allowed by the SEC. Now, the SEC would not also allow a name if such name is already protected by law. So, anong law protects a particular name? So, pwedeng under intellectual property, the intellectual property code, trademarks, trade names. So yun, maybe it could be included in a particular patent or copyright na nagamit na, so protected by law. There are even laws under business name, those names registered with the Department of Trade and Industry. So those names could no longer be appropriated if it's the same as that of what is being going to be used by a corporate name. Now, incidentally, the SEC also now requires that if you're going to use a trade name for your corporation, you must already include that as part of your corporate name in your articles of incorporation. For example, if you're using let's say McDonald's, so I think the Philippine owner of that franchise is one of the cases that we have actually Golden Arches Corporation. So that's McDonald's. So pwedeng makalagay, example, Golden Arches, and then doing business in the name and style of McDonald's Philippines. So yun. That's already being required by the SEC. What else? The SEC would not allow a corporate name when the use of such name is contrary to existing law and rules and regulations. All right. Now, however, under the old code, the law uses the rule as to whether or not the name is identical or deceptively or convincingly similar to a name that was already used, or was already being used. Now, is it still applicable? We believe so, yes. Because in the case of Philips Export BV versus Court of Appeals, the Supreme Court held that to fall within the prohibition of the old SEC revised guidelines on deceptively or confusingly similar corporate names, two requisites must be proven. Number one, that the complainant corporation acquired a prior right over the use of such corporate name. So prior right is being required. So in section 17, it also mentions about this one. Why? Because if the name is already protected by law. So that's prior right. So that's number one. Second is if the proposed name is either identical or deceptively or confusingly similar to that of any existing corporation or to any other name already protected by law. Again, that's already incorporated under Section 17 of our code. And lastly, if it is patently deceptive, confusing, or contrary to existing laws. Again, also included when the use of such name is contrary to existing law, rules, and regulations. What else? We have, of course, the guidelines of the SEC to consider when it comes to the use of corporate names. Now, I mentioned earlier that in the use of the choice of a corporate name, you must be able to distinguish it from another name which is already being used. So if you're going just to, let's say, if the main word for your corporate name is, again, going back, okay, that's the main role. So butaan mo lang. Let's say before that you say D, tapos next, okay, shoe manufacturing corporation. So that's your corporate name, the OK shoe manufacturing corporation. So if that particular corporate name is already being used by another corporation instead of the entire word that THE, what is being used is D, the letter D, and then apostrophe, D-O-K. So yun, parang the SEC will now flag it as something which is similar, or they cannot distinguish it from another corporation. Now, in order, let's say, for the incorporator to distinguish it from the name that is already being used, they now included in the corporate name the following. Okay, so if they're going to place that in, or they change the word corporation to an abbreviation of corp or inc, would it now distinguish it from the similar name? The answer to that is no. What about the use of punctuations, articles, conjunctions, or contractions? Again, the answer to that is no. Why? Because under Section 17, again, the name is not distinguishable even if it contains one or more of the following. Number one, the word corporation, company, incorporated, limited liability, or an abbreviation of such other words. Second, by punctuations, articles, conjunctions, contractions, prepositions, abbreviations, different tenses, spacing, or number of the same word or phrase. So yun, it would not be considered as that it would distinguish it from another or a similar name. Right? Now, let me refer you then to SEC Memorandum Circular number 13-2019, which refers to the amended guidelines and procedures in the use of partnership names for corporations. I'm no longer going to discuss that in detail. I just leave it to you to read. Right? Anyway, that's something that I will not be asking in the examination, because that's something that we're going to use for your own practical purpose when you're going to assist in the incorporation process. Now, may the Securities and Exchange Commission compel a corporation to change its corporate name if it subsequently rules that the same is a protected name? The answer to that is found in Section 14 of the Code. Now, the corporation, through its incorporators, undertake to change the name of the corporation immediately upon receipt of notice from the Commission that another corporation, partnership, or person has acquired a prior right to the use of such name, that the name has been declared not distinguishable from a corporation, or that it is contrary to law, public morals, good customs, and public policy. So where do we find it? It's in Section 14 of the Code. When it comes to form, and in the 10th paragraph, it states there that the incorporators undertake to change the name of the corporation immediately upon receipt of notice in Commission. So yun, that's already included in the law. So that's an undertaking made under oath by the corporators. Now, is changing the corporate name allowed? Well, the answer to that is yes. Will it result in the dissolution of the corporation? The answer to that is no, it does not. So, sino mas mahapos mag-change? Corporate name or the name of a natural person? Both of which you'll be you'll be able to experience once in your law practice. Well, on my part, I had several cases where I assisted the change in name of the client. Kasi I remember one, sa iya birth certificate, nakabutang to, his first name is Nicasio. But all this time, he was using the name Arturo. So, parang layo, Arturo and Nicasio. But that was the time when wala pa yung new law allowing the local civil registrar to make corrections on first names. Now, it's already summary in nature, no? Pag first name ang it pa-change mo. It does not need to be through the SEC anymore, to the courts anymore. So local civil registrar lang pwede. Basta first name lang, no? But before, but if it would include, if it would involve the surname, basta hindi siya typographical or what we call ang mga nung-tutong na mga items, dapat you have to go to court to change that family name. So it's kind of it's not difficult, but it's tedious. How about corporate name? Tapos lang. All that you have to do is choose a name that you would want to use, to change, and just go to the process of amendment of the Articles of Incorporation. So it's allowed. Right? The name of a corporation will be changed by way of an amendment of the Articles of Incorporation as prescribed under Section 15 of the Code. The change in corporate name, however, does not result to the dissolution of the corporation, or in the dissolution of the corporation. The change in corporate name has no effect on the identity of the corporation or in its property, rights, or liabilities. The corporation, upon such change in its name, is in no sense a new corporation. It is the same corporation with a different name, and its character is in no respect changed. That was the pronouncement of the Supreme Court in the case of Zwillig Freight and Cargo Systems versus NLRC, 701 SCRA 572. Okay, so remember that. Now, let's now proceed to the next entry in our Articles of Incorporation. So after we were able to choose corporate name, and that's approved by the Securities and Exchange Commission to be used, what is the next entry in the AOI that we should be able to assist our clients with? It's the purpose, or the specific purpose or purposes for which the corporation is being formed. So the purpose clause, we're now referring to the purpose clause. Now, when it comes to the purpose clause of the corporation, its significance is that it confers as well as limits the powers that a corporation may exercise. Now, in our discussion yesterday, we learn about the ultra vires doctrine. Okay? Diba? Ultra vires doctrine, which tells us that a corporation cannot exercise or enter into acts which are beyond what is expressly authorized by law to it, or as what is stated in its articles of incorporation. Also, Section 44 of the code specifically states that no corporation shall possess or exercise corporate powers other than those conferred by the code or by its articles of incorporation, and except as necessary or incidental to the exercise of the powers conferred. So it makes reference to the articles of incorporation. So ano yun? What item in the articles of incorporation does Section 44 refer to? That's your purpose clause. Okay? The significance of the purpose clause, according to Dean Villanueva, is in the articles of incorporation is that it confers as well as limits the powers that the corporation may exercise. That's the reason why when we say preparation of the purpose clause, it's sometimes considered as an art, but also it's considered as, the application of skill and talent, of a lawyer. And of course, it takes a lot of experience and anticipation of what should be stated in the purpose clause. There are, however, certain areas of activities where the law requires a specific purpose clause. One of which is if the corporation is going to be engaged in the business of financing. So, dapat nakabutang dun sa purpose clause. Specific requirement. At the same time, as I mentioned earlier, pag you're going to be engaged in the issuance of securities that is governed by the Securities Regulations Code. So it should be included in your purpose clause. But the crafting of the purpose clause is sometimes really important for us to learn. Why? Because again, it confers as well as limits the powers that the corporation may exercise. Okay. Now, the purpose clause is a source of a corporation's power. Section 44 of the Code, as I've said, provides no corporation shall possess or exercise corporate powers other than those conferred by this code or by its articles of incorporation. Now, what are some reasons for indicating the purpose of a corporation in its AOI? So, as suggested by Villanueva, investors, some of these reasons are the following. Number one, so that investors may know or be informed the kind of business the corporation deals with. So, remember when we say the AOI as the contract or the primary charter, it binds even outsiders. So once they subscribe to the shares of stock, the corporation, and become stockholders, they're bound as to what is stated in the articles of incorporation. So before they do so, they must first look into what is this corporation all about. So we have to look into the primary purpose. Also, if they know the business of the corporation, then they could say protect the corporation and themselves against abuses by management or by the board of directors. How so? So, as I have discussed yesterday, diba, there are certain express powers that are only reserved to the board of directors, just like the power to sue and be sued. That's exclusively within the province or the office of the board of directors. But when it comes to investment of corporate funds to other corporations or to other businesses or to other purposes, then we might need to go back to our shareholders and ask for their ratificatory vote. That is required under Section 41 of the Code. So, if the shareholders knows what the business of the corporation is by looking into the primary purpose of the corporation, then it could protect their interest and that of the corporation by questioning a particular decision of the board in investing money outside of the corporation or outside of the business or purpose for which the corporation was organized. So yun, that's provided for by the knowledge of or information provided to shareholders based on the purpose clause of the corporation. What else? The purpose clause would also allow the board of directors and the corporate officers or management to know the limits of their actions. Again, this is going in the discussion of an ultra vires act, no, of the first time sa isang korporasyon. Could the board of directors of the corporation engage in this type of business knowing that the primary purpose of the corporation does not so provide for it? So yun, would they now claim good faith in saying that, well, it's still within the primary purpose of the corporation and therefore binding to the corporation? So dapat, whatever they decide on, the exercise of the powers of the corporation, it should be within those authorized by law or those which are stated in its primary purpose. Pag wala, then they could be held questionable for that, no? Or the transaction to be considered as ultra vires. And lastly, what is stated in the primary purpose would also enable third parties who are dealing with the corporation to have an information whether the same or the act is within the purpose of the corporation. Again, also going towards whether the particular purpose of the corporation is considered as within its powers. Now, there is this legal opinion that was issued by the SEC pertaining to purpose clause. No, I am referring to the legal opinion issued by the SEC. I'm going to share that with you. So, all right. I hope you see it, no? So it's a legal opinion dated October 22, 2008. All right. So it's SEC opinion number 08-24. Now, this is something that we could use later on, no? In practice. So this refers to a letter seeking clarification whether or not the business of this particular corporation could legally include what we would consider as new business. Kasi the query said, can the corporation legally engage in the business of supplying, managing, selling, and or subleasing out to third parties indoor and outdoor advertising materials, sites and space in the Philippines? Now, they are juxtaposing this with the primary purpose as stated in the Articles of Incorporation. Ano nakalagay sa Articles of Incorporation? States, the primary purpose of this corporation is to engage in, operate, and maintain an advertising, promotions, and wholesale marketing business. So it's kind of general, no? But now, what they're asking is, if it is a specific type of undertaking or business, it is still within the primary purpose of the corporation. Yeah, because, well, kung hindi, then they will not be able to engage there too, because it would become ultra vires. And of course, that's also something to do with, let's say, government permitting. Halimbawa, pag nag-apply ka ng billboard or the use of LED walls, it may not be allowed by the local government because if they look into the primary purpose, it's not there. So yun, that is something that they really wanted to know kung arabala siya or hindi. And they don't want to amend their articles of incorporation by changing the primary purpose. So the SEC came up with this legal opinion, and of course, the premise is discussing the powers of the corporation. The corporation may pursue any and all related activities covered by its purpose clause. So we know that, no? So pwede siya mag-pursue activities covered by its purpose clause. Alright, so it makes mention of Section 36. Well, this is now Section 35, or on corporate powers and capacity. And this is what I mentioned yesterday as the catch-all phrase, no? To exercise such other powers as may be essential or necessary to carry out its purpose or purposes as stated in the Articles of Incorporation. Alright? Now, the SEC then said na pwede mong i-stretch ang purpose ng korporasyon. No? Because it states here that it's basic and elementary that the corporation could only or will only have such powers that are granted by law or as stated in its charter or the articles of incorporation for the matter. So, kumbaga, it could only exercise those powers. However, the SEC is of the opinion that it could stretch the purpose clause. The SEC opinion on stretching the purpose clause stated that it is settled that it is only in the business for which it was lawfully organized and which is stated in the Articles of Incorporation the corporation should engage in. But if the business is necessary for the accomplishment of the purpose of the corporation or incident to it, the corporation may also engage in such business. So this is a matter of fact, it is even legal to stretch the meaning of the purpose clause to cover new and unexpected situations. Now the SEC here offered some reasons why the purpose clause may not be able to cover new businesses. No? There will always be instances when doubts may arise as to whether an act may be reasonably implied from the purposes of the corporation. These doubts will sometimes be due to poor draftsmanship or lack of foresight on the part of the original incorporators or their legal counsel, or as is oftentimes the case, situations or circumstances may come up which could not have been foreseen at the time of the incorporation. So that's the reason why the SEC allows the stretching of the purpose clause to cover those new and unexpected situations. Now, however, if you want to have a complete understanding of this, then you may want to also refer to what we have discussed yesterday as to the ruling of the Supreme Court in the case of Montelibano versus Bacolod Municipality when it comes to interpreting the purpose clause of a corporation, whether its action will fall under the classification of an ultra vires act of the corporation. Right? So that's purpose clause for us. Now the next item in the Articles of Incorporation as required under Section 13 is the principal place of business. All right. So paragraph C, the place where the principal office of the corporation is located, which must be within the Philippines. So, what is the significance then of the place of business of a corporation? Right. Now, of course, the principal place of business of the corporation, as indicated in its Articles of Incorporation, would be indicative of the residence address of the corporation. Now, the residence of the corporation is important when we consider the place where meetings of the board of directors or the shareholders in a stock corporation should be held, or meetings of the board of trustees or the members of the corporation should be conducted. So yun, number one, place of meetings. It's important. Second, okay, the residence of the corporation is also important in determining a lot of things. No? Number one would have to be venue in an action where or a suit where the corporation is a party. So either the corporation is a plaintiff or the corporation is a defendant. Venue of actions, no, not jurisdiction of court. Now, venue where the case should be filed, proper venue is dependent on the residence of the corporation. In the case of Young Auto Supply Company versus Court of Appeals, the Supreme Court held that a corporation in a metaphysical sense is a residence of the place where its principal office is located as stated in its Articles of Incorporation, and it cannot be allowed to file a personal action in place other than that place. So yun, that's the case of Young Auto Supply Company versus Court of Appeals. But also you have to look into what the Supreme Court said in the case of Hyatt. The case of Hyatt Elevators and the case of Golden Arches. those cases also deals with the principal place of business of a corporation. Okay? Now, in the case of Clan Visilia Radio System versus Antillon, the Supreme Court held place of residence of a corporation is the place of its principal office. In the case of Hyatt Elevators and Escalators Corporation versus Gold Star Philippines, the Supreme Court held that although the rules of court do not provide expressly, jurisprudence has settled that the place where the principal office of the corporation is located, as stated in its articles, indeed establishes its residence. This particular ruling is important in determining the venue of an action by or against a corporation as stated in the complaint. Also, just remember what the Supreme Court held in the case of Pilipinas Shell Petroleum Corporation versus Royal Ferry. Well, in this particular case, remember the nature of the case was controlling as to the determination of venue. Now, in intra-corporate disputes, the residence of the corporation is also determinative of venue in a case involving intra-corporate disputes. Okay, so we remember that. Now, later on, when we go to another entry in the Articles of Incorporation for stock corporations, we will go back to the discussion on the importance and the significance of the corporation's principal place of business. Please also be aware of SEC Memorandum Number 6, Series of 2016. This is the Omnibus Guidelines on Principal Office Address and address of each incorporators, directors, or trustees or partners. So, dapat specific na siya as stated in the Articles of Incorporation, not merely sa Iloilo City or City of Makati, etc. So, dapat nakabutang specific place of business of the corporation. The next item in the Articles of Incorporation is our corporate term. The controlling provision is Section 11 of our Corporation Code. Now, the corporation shall have perpetual existence unless its Articles of Incorporation provides otherwise. This is also recognized as one of the express powers of the corporation under Section 35 to have perpetual existence. However, it's not mandatory for corporations to have perpetual existence. As stated in Section 11, it states there that corporations shall have perpetual existence unless its Articles of Incorporation provides otherwise. And therefore, what is stated in the AOI is still controlling. If we go by the incorporation process under the SEC's SPARC and under the field corporate existence, there's a drop-down choice there, perpetual 50 years, I think 20 years, 10 years, 15 years, 10, and 5. So you're still allowed to choose a fixed term rather than choosing perpetual existence. Right? Section 11 also contains the transitory provisions. Those corporations which were incorporated prior to the revision and migrating towards the new default rule, which is perpetual. So for a time that was really significant. But if we're going to incorporate a corporation under the revised code, this will no longer be applicable because of the fact that we now start with perpetual for those fixed periods. This would be significant if we're dealing with corporations or clients whose corporations were incorporated prior to the revision, because the choice of perpetual existence would be significant when it comes to the exercise of the power to either extend or shorten corporate term. Okay? The provision of Section 11 also provides for what we call as the revival clause. If a corporation whose original term already expired is placed under if the directors and shareholders decides to revive the said corporation, that it could do so under Section 11 because of the revival clause, no, provided in Section 11. Just be familiar, no, with the revival clause, all right, under Section 11. So now, as what is stated under the code, the corporate term is now perpetual. All right. What else? No? Aside from the term of existence, we have the names, the nationalities, and residence addresses of the incorporators. So, sinong mga incorporators? No? Who are the incorporators of a corporation? The controlling provision is Section 10 of the RCC. Number and qualifications of incorporators. The code states, any person, partnership, association, or corporation, singly or jointly with others, but not more than 15 in number, may organize a corporation for any lawful purpose or purposes. Now, look at the provision of the code. It speaks about the number of incorporators either singly or jointly. What is the current guideline of the SEC? If you're going to incorporate an aggregate corporation or a corporation with shareholders that are more than one, aggregate corporation, SEC Memorandum Circular Number 16-2019 requires that outside of an OPC or a one-person corporation, all corporations, whether stock or non-stock, shall have at least 2 incorporators. So dapat 2, no? Pag aggregate corporations or a corporation outside of OPC. And therefore, we might interpret that Section 10 here, when it states singly, properly refers to an OPC or a one-person corporation, whereby we have only a single shareholder. Pero pag an aggregate corporation, the SEC requires at least 2 incorporators. Sinong pwedeng mag-incorporate? Any person and juridical persons, such as a partnership or a corporation, may be incorporators, provided that if the incorporator is a natural person, he must be of legal age, right? Partnerships, natural persons who are licensed to practice of professions, and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation. We have learned this from the case that we have heard, the case of Acevedo Optical, right? Yeah. So, those are your incorporators as provided under Section 10 of the Code. Okay? Now, aside from this, we also have to include the number of directors, which shall not be more than 15, or a number of trustees, which may be more than 15 when it comes to a non-stock corporation. We also have to state the names, nationalities, and residence, the residence addresses of persons who shall act as directors or trustees. In the Articles of Incorporation, if it is a stock corporation, we should also be able to state therein the capital structure at incorporation. Kumbaga, the number of authorized capital stock, the number of shares with which it would be divided, and the subscription to be made by the incorporators. All right, so that refers to the capital stock at registration. So what is the provision of the code that governs capital stock or minimum capital stock at the time of incorporation? That's Section 12 of the code. Now, Section 12 simply states, stock corporations shall not be required to have minimum capital stock, except as otherwise specifically provided for by law. In the book of Aquino, he enumerates there certain businesses where special law requires a minimum paid-up capitalization. So that would have to be followed. Otherwise, the SEC or the government regulatory agency would not provide or give a favorable recommendation or endorsement, and the SEC would not be approving the Articles of Incorporation if the required minimum paid-up capitalization is not met. Right? Of course, that would be also considered as one of the grounds for the disapproval of the AOI in accordance with Section 16 of the Code. So at the time of incorporation, walang minimum capital stock required as a general rule. You don't even observe the 25% rule, unlike that when we increase our capital stock based on the provisions of Section 37 of the Code. So that's something that we have to consider. All right. So capital stock at the time of incorporation. I'll again go back to this when we will have our class face to face, so that I'll be able to explain this together with the discussion on how the corporation exercises its power to either increase or decrease its capital stock. Okay, so of course, those are, well, there are the other provisions in the AOI, but I'll just leave it for you to discuss. Now, the last item that I'm going to be discussing on the AOI is how we amend the Articles of Incorporation. So it is provided under Section 15 of the Code. Now, this is one of those express powers of the corporation as enumerated under Section 35, the power to amend its Articles of Incorporation. However, this particular power requires the ratification or the participation of the shareholders of the corporation. So hindi siya exclusively within the office of the Board of Directors of the Board of Justice lang. You have to involve the decision of the shareholders or the members of the corporation. So the voting requirement is majority of the board plus ratificatory vote of the shareholders representing at least 2/3 of the outstanding capital stock, or if it is a non-stock corporation, 2/3 of the members of the said non-stock corporation. So that's the requirement when it comes to the amendment of the Articles of Incorporation. But in a stock corporation, remember that this is without prejudice to the operational right of dissenting shareholders. Yun nga lang, there are just certain instances where operational right is available. One of which, as I mentioned yesterday, was when if the corporation exercises the power to extend or shorten its corporate term. Section 36 in relation to Section 80 of the revised corporation code. Also, take note of that. And of course, no amendments would be effective until the SEC approves the amendment by way of the issuance of a certificate of amendment. Now, compare this with the provision of the bylaws which pertains to amendment of the bylaws naman. Now, in the amendment of the bylaws, the difference is that there is a farewell. Lastly, no, on the bylaws, just one important tip, no, is to read the case of Gokongwei versus SEC and the case of Butika Fleischer versus Butika Nalasco, and look into the manner by which the bylaw provisions should be amended. All right. So I think those are the things that are necessary, for you to be equipped in your midterm examinations. Okay. So once again, thank you everyone for being with me tonight. I hope we learned a lot of things, going towards the midterms, and I wish you all the best, on our midterm examinations. Mr. Biddle, I already intimated that I might move the midterm examinations to Monday, but all should agree. All right, everybody should agree for it to be moved. Otherwise, we'll proceed with our original schedule on Saturday. All right. So the only condition that I'll accept for me to move the exam is if all of the students agree to it for it to be moved on Monday. Right. So thank
For
you.
clarification, sir.
Yes.
All sections po, no?
Sorry.
All sections.
Yes,
should
of course.
agree.
All sections. We'll be giving the exams together. So from Saturday, as originally provided in our schedule, to Monday. But everyone should agree. All right? So that nobody will complain na excited na siguro ang iba magpa sa exam sa Saturday. So, parang they don't want to be. Anyway, so thank you everyone. I just request Mr. Flores, okay, it's timely for you to lead our closing prayer.
In the name of the Father, the Son, and the Holy Spirit. Amen. Glory be to the Father, and to the Son, and to the Holy Spirit, as it was in the beginning, is now, and ever shall be, world without end. Amen. In the name of the Father,
Thank you,
Son, and
everyone.
Holy Spirit.
Stay safe.
Amen. Thank you, sir.
Thank you, sir.